Hello everybody and welcome to today's installment as part of the ENS Africa CPD series. For those who are joining us for the first time today, my name is Jessica Blumenthal and I'm a director in the Banking and Finance Department sitting in our Cape Town office. This CPD series is presented by our Banking and Finance Department for our financial services clients and of course for anyone else who's interested in the topics that we're presenting on. It has been accredited for CPD hours because ENS Africa is an accredited CPD provider. So that means that if you manage to stay on for the entire webinar and we're able to verify that, then we can issue you with the CPD, we will issue you with the CPD certificate at the end if you are needing one for your CPD requirements. We've offered this CPD series now for the last 3 years, and we've used last year's series and this year's series to really showcase and discuss topics that we think are emerging and are of importance to the financial services sector. So last year, while some of the topics were introductory and really we were looking to use this platform to raise general awareness and understanding of these emerging risks and opportunities, this year we've pulled together experts from our different practice areas and different jurisdictions to bring you essentially masterclasses or deeper dives into some topics that we think are really important. The topic today is climate litigation, and we are very happy to be able to welcome Gillian Griffiths of our Mauritian office, who will be moderating a panel. And that panel will be comprised of Thierry Koenig, who heads up our office in Mauritius, and also Beverly Oosthuizen, a litigator in our South African offices. And they'll be discussing the rise of climate litigation, which we have flagged as one of the trends to watch. Just some housekeeping before I hand over to Gillian and let her introduce her panel more fully and also kick off the discussion. You have had the opportunity to send in questions, and for those who have sent in questions, thank you very much. We have taken those into account. But if you do think of further questions while you're listening to the panelists' discussion, you can use the Q&A block at the bottom of your screen. Please be careful not to use the chat block because we can't reply to your questions in the chat. If you use the Q&A block and for whatever reason we don't get to answer the questions during the session, then at least we'll be able to contact you afterwards. So please do use that block. I've already mentioned that if you want a CPD certificate at the end of this masterclass, please make sure you do stay online for the duration of the hour. And I think that that's all from me from a housekeeping perspective. I'm going to hand across now to Gillian, and she, as I said, will introduce her panel and then kick off the discussion. Thanks, Gillian.
Hello, everybody. Thanks for joining us today for our webinar, Climate Litigation, the Rise of Climate Action. Our panelists today are Thierry Koenig and Beverly Oosthuizen. Thierry is the head of ENS Africa in Mauritius, Mauritius' oldest and largest law firm. Thierry is a senior attorney and his practice spans across dispute resolution, corporate, commercial, and banking. He has several decades of experience in complex commercial litigation, arbitration, insolvency, insurance, capital markets, and corporate structuring. Thierry has also advised on numerous government working groups tasked with drafting and reviewing legislation. Beverly is a senior associate in the Dispute Resolution Department at ENS Africa based in South Africa. She has extensive experience in a range of commercial transactions and disputes, having advised and represented both local and international clients from commercial, financial, mining, CGI, logistics, retail, and others. Her experience includes high court action and motion proceedings in South Africa, Botswana, Zambia, Zimbabwe, and Eswatini, as well as arbitrations conducted under the auspices of AFSA and the ICC. She has a strong interest in the growing field of climate litigation or green litigation. And my name is Gillian Griffiths. I'm an Australian solicitor, non-practicing barrister of England and Wales, fellow of the Chartered Institute of Arbitrators, and an associate in the litigation team here at ENS Africa, Mauritius. So today we'll be talking about climate change litigation in 2 parts. In the first part, I'll be speaking with Beverly about the current state of climate litigation, and we'll be looking at current trends worldwide, looking at the legislative regimes in South Africa and Mauritius, and then looking at some different kinds of climate suits that are being brought around the world. In the second part, I'll be speaking to Thierry on the other side of the litigation coin, and we'll be looking at possible defenses to climate suits, looking at the impact of climate litigation on business, and finishing up with some strategies to mitigate climate litigation risk. Then at the end, we should hopefully have some time for questions. So to jump right in, Beverly, can you give us a bit of an overview of the current landscape of climate litigation?
Morning, Gillian. Thanks so much. Yes, this is a very interesting and exciting field of law. It is definitely an accelerating field, and we're finding that claims are arising not only out of new pieces of law or legislation, but out of the existing legal frameworks that operate within countries. We're finding cases that are being brought by private citizens against their governments. We're finding private citizens or shareholders instituting proceedings against companies or the company's own board of directors. And we're even finding instances where complaints or requests for investigations are being laid with the International Criminal Court based on climate change violations. So it really is a wide-reaching area of the law and a very, very interesting area to stay abreast of.
Fabulous. And let's narrow in now a bit in the legislative regimes. Can you, first of all, give us a quick rundown on the framework of the Paris Agreement and what it means for the nations that have ratified it?
Excellent. A lot of the litigation that we see that has arisen since 2015 is finding impetus and flowing from what is known as the Paris Agreement. The Paris Agreement is a legally binding international treaty that governs climate change and places obligations on each signatory state to take steps within their own domestic environments to achieve the goal of this convention. And the goal of the convention is to hold the increase in global average temperature to well below 2 degrees Celsius above pre-industrial levels. So that's the platform from which they would be judging the increase in temperature. And most importantly, to limit the temperature increase to 1.5 degrees Celsius above those pre-industrial levels. And the purpose is to avoid further climate change impacts. Now, for a lot of us, if you're like me, when we hear degrees and where we at, it all sometimes sounds a little bit gray. So just to put it in context, where the world is sitting at the moment is 1.2 degrees Celsius above pre-industrial levels. And the purpose of this agreement is to prevent us from increasing another 0.3 degrees to hit that 1.5 degree climate change. Scientists are of the view that we would see an acceleration in climate-related events should the global temperature reach above 1.5. So droughts, floods, all sorts of disruption to what we've come to experience as the usual climate of the areas in which we stay. Now, South Africa, together with 196 states, have signed the Paris Agreement, which means we are legally committed to achieving the goal of the Paris Agreement. We have to date, I'm happy to say, complied with our obligations. We've delivered nationally determined contributions, which I will discuss in more detail later, and even low emission development strategies. And these are documents that are required to be delivered in terms of the Paris Agreement by each country to ascertain what steps it will take to achieve the goal of the Paris Agreement.
Great, fabulous. Thank you for that overview. Let's have a more specific look at the regimes that apply in our jurisdictions. So we'll have a quick talk about Mauritius and what's happening in Mauritius. So far, we don't have a lot of specific legislation about climate change and related obligations. There is the Climate Change Act 2020, but this is targeted at public institutions. It sets up bodies for implementing different measures, for looking for foreign investment to fund climate change projects. But in the private sector, there is one recent guideline which was introduced from the Bank of Mauritius last year, which will be coming into effect in 1 January 2024. And This guideline is significant because it will apply to all financial institutions, and financial institutions will mean all institutions that have a license from the Bank of Mauritius, so all deposit-taking institutions. And there are various requirements which will come into effect, including the requirement to monitor different risks, to manage and implement different strategies. But one of the most significant things is that as of 1 January 2024, all financial institutions will be required to disclose in their annual reports information on climate-related and environmental financial risks they're exposed to, the potential impact of material risks, and their approach to managing these risks. So this is something that financial institutions need to start preparing for in advance of next year. And aside from the guideline, we can only really see for now potential suits might be able to be brought under the Code Civil, under the general contract and tort liabilities under Chapter 10, where someone needs to compensate for the foot or the harm that they've done. And then potentially some of the more general director's duties, being the director's duty to exercise care and skill, and also to act in the best interest of the company. And we'll talk a little bit more about this later. And so now let's move on to South Africa. And Beverly, can you give us a bit of an overview of what the regime is over there?
Absolutely. So Gillian, just to carry on from the Paris Agreement, as South Africa has ratified this and it has become a legally enforceable convention as against South Africa will have to work toward achieving those goals. So as such, I think it's important to see that Paris Agreement as being something that South Africa and those entities that operate within the South African economy needs to take cognizance of. Why this is particularly important for South Africa and the role players within our industry is that South Africa has identified in its nationally determined contribution document that was submitted to the UN in 2021 that South Africa is actually warming at twice the global rate. And South Africa has also been identified as one of the 15 highest emitters of GHG, that's greenhouse gas or carbon emissions, which means that South Africa has a lot of work to do to meet the goals of the Paris Agreement. And more importantly, it's going to attract a lot of international attention from other signatory states who are wanting to achieve those goals, because the Paris Agreement makes provision for fellow parties to assist one another, not only with funding, but also with ability and resources to achieve these shared goals. So South Africa is definitely looking at this in their the low emission development strategy that South Africa submitted to the UN, which basically indicates to the UN how it plans to achieve a net zero emission by 2050. South Africa has put out a plan, and I think that plan is something that industry needs to take notice of. The plan suggests that during 2020, so the decade 2020-2030, South Africa is going to be focusing on its emission reduction in its electricity sector. Now, we can appreciate that comes with some hurdles given our current load shedding and the move away from coal or fossil fuel based power stations. So that's what 2020 is intended to look like in our reduction space. 2030 is meant to bring in a decade of deeper transition entirely away from fossil fuels in our energy sector, and also starting to focus on our transport sector. So any clients or industries finding themselves in the transport sector, it appears that South Africa is intending to focus on those industries in 2030 to 2040 as it currently stands. From 2040 onwards to 2050, South Africa plans to focus on the harder to mitigate sectors. It's the catch-all phrase. So those are the general plans under the Paris Agreement. And what South Africa is doing in order to give legs to that plan is that they have currently tabled a climate change bill. Now, the climate change bill is intended to enable the development of effective climate change response and long-term transitions to a low carbon economy. And on consideration of the bill, you'll see, for importance of today, the government intends to create what is called a carbon budget, and every participant in the economy who produces greenhouse gases will be given a carbon budget that you are only entitled to emit a certain number of carbon or GHG emissions in any particular life cycle. Your budget will be gauged over a period of 5 years, after which you can ask for it to be reviewed, adjusted, bearing in mind that the intention of the government is always to, with increasingly aggressive steps, reduce emissions. So it's likely that the first budget you get will be more generous than the budgets you get in preceding years. The government also intends to highlight or identify key sectors where they feel there are the highest contributions in emissions, and to focus primarily on those sectors in order to reduce those emissions and to bring those sectors in line with a strategy that's geared toward a net zero of 2050. So any participants in industry sectors that by their very nature result in high emission levels, those are the sectors and the areas where government is likely to first commence its efforts at reducing those emissions and setting carbon budgets. Tied into what I mentioned earlier about signatory states to the Paris Agreement assisting one another, South Africa is in fact the first signatory state who has concluded a partnership. It's called the Just Energy Transition Partnership. We've concluded this with France, Germany, the UK, USA, and the EU in general. And the focus of this partnership is for those member states to assist South Africa with financial resources and other means to assist South Africa in achieving the net zero of 2050. And the primary focus is going to be on our energy sector. And the goal of this particular partnership is to assist South Africa to move to a 42% non-fossil fuel energy resource by 2030. That's 7 years' time. So that's an exciting development.
Sorry, carry on.
No, I was just going to say, other than that, just our current existing legislation will remain in place, but we just need to read in there that wherever there's an obligation on directors, parties, individuals to consider environmental impact in whatever they do, it is highly probable that courts now will read in that there is a requirement to consider climate change in whatever you're doing within those existing frameworks.
That's great. Thank you for that really comprehensive overview. It sounds like there's a lot of work ahead for South Africa, but there is a plan, and I'm sure that it will happen in some time. So let's now have a look and get into the different kinds of climate change suits which are being brought all around the world. And I'll just pull up we've got quickly to show you a summary table of different types of legislation different types of suits which are being brought into different categories of heads of claim. So there are less common things we're seeing for now, increasingly likely risk of claims, and most likely for now. And we'll hopefully briefly get through all of them, but if not, we'll get through the most relevant ones for everybody. So let's start off with the right-based claims in the less common section. So these kinds of cases typically are alleging a violation of human rights under a particular constitution or a treaty. And the violation of rights is usually said to have been caused directly by climate change and its effects. So in South Africa in 2021, the African Climate Alliance brought a constitutional case against the Minister of Mineral Resources and Energy, Beverly, can you tell us a little bit about this case?
Sure. So this is a very interesting case for South Africa, and I think it speaks to what I said, that the courts are going to read in climate responsibilities into the frameworks of existing legislation. It doesn't need standalone legislation in order to take wing or take flight. So in this particular matter, it was a youth-led constitutional challenge against the South African Minister of Mineral Resources and Energy, who had approved the purchase of to procure 1,500 megawatt new coal-fired power station in order to contribute to the country's energy deficit that we are experiencing at the moment. The challenge was that this disregards, and it's a threat to society's environmental rights, as well as the interests of the child and your right to life, dignity, and equality. And the applicants relied on their constitutional rights to challenge the government's decision to procure further fossil fuel energy. And the court, in considering it, actually found and agreed that the government's responsibility in its duties to its citizens was to take cognizance of South Africa's obligations under the Paris Agreement to climate change, and also to take cognizance of the impact of further climate change on the lives of its citizens. And the government the approval of the EIA was actually set aside, and everything was sent back to the drawing board.
Wow, that sounds like quite a landmark case, and one that might be setting precedents for other cases to come. And in that same thread, I'll quickly just mention there's another really interesting rights-based case, which was brought by a Peruvian farmer in Germany against Germany's largest electricity producer, which is RWE. The case was brought back in 2015, but has been delayed because of COVID. However, it's still ongoing. And so the case alleges around Mr. Yuya suing the RWE for a financial contribution, alleging that RWE knowingly emitted greenhouse gases, and this has contributed to increased flooding in his town of Huaraz, which sits below a glacial lake. What's novel about this case is that RWE doesn't have any power plants in South America, and so Mr. Yuya won't be able to establish or rely on any direct causal link between RWE's CO2 emissions and the increased flooding events. Mr. Yuya says that a new dam needs to be constructed as a preventative measure from the increased flooding events, and he's seeking an order that RWE contribute 0.47% of these costs, as he says this allegedly corresponds to RWE's share of global greenhouse gas emissions since the beginning of industrialization. So there's been a lot of procedural hurdles with this case, but last year, German judges, court-appointed experts and lawyers conducted a site visit to Huaraz, and an expert report is due later in the year. So it'd be interesting to see how this quite not causally strong claim will continue. And so quickly, let's move on to the negligence and tort claims that we're seeing. So in the Netherlands, there have been two landmark cases that have been brought in relation to duties of care, and they were brought by advocacy groups. Beverly, can you tell us a little bit about these cases?
Absolutely. So the two cases, they're quite early cases. We've seen a fair amount of litigation arising out of mainland Europe. And some of these, this is the one case I'm going to speak about today about environmental group, Uganda Foundation, was brought in 2015, which means the very year that the Paris Agreement was signed. And in this particular matter, you'll see that an environmental group has actually brought proceedings against the state of the Netherlands itself. Citizens, over 900 Dutch citizens, brought a class action against the state, indicating that it simply failed to take sufficient steps in order to reduce carbon emissions. And the citizens were demanding more of their government to achieve a carbon zero status. The basis for bringing this application was based on the citizens' rights to life, to family life, to home, and to a private life. Now, those are rights that are demarcated in the European Convention on Human Rights. And the court came to the rescue of the citizens and found that the Dutch government had failed to take sufficient or adequate steps, and in fact ordered the government to take steps to reduce greenhouse gases by up to at least 25% by 2020. Now, that was a landmark case and certainly has set the tone for other cases. The Dutch courts followed that case in another class action brought in 2019. So that's 4 years later. And this time it was brought against the Royal Dutch Shell itself, so Shell as we know it. And it was brought by an environmental group, and again, further Dutch citizens who wanted Shell to reduce its CO2 emissions by 45% by 2030. Now, that is a massive, it's almost a half reduction. And it, as I said, built on the previous case that had been brought out. And the court found that that Shell was required to do further steps or take further steps in order to achieve the 2050 net zero requirements of the Paris Agreement, and ordered that Shell is to reduce its carbon emissions by the 45% claimed by 2030, and in fact has been ordered to be net zero by 2050. So Shell is currently under a court order requiring it to be net zero by 2050, and this will impact its operations and also its future investments, and we'll touch on that in due course.
That's really interesting, how far-reaching the court can grasp into the obligations on private companies. Wow. And just to put into perspective, perhaps maybe if it's that the Netherlands is a civil law country, on the other side of the scale in New Zealand and Australia, there have been novel duties of care cases that have been brought, but neither of these have been successful. They've both been heartily rejected by the court. So in New Zealand, in Smith and Fonterra, Mr. Smith, a Maori man, brought a case against Fonterra, which is the largest company in New Zealand and a very big dairy producer, along with other energy companies, claiming that the emissions would cause rising sea levels and damage to the land that he's interested in as a Maori person. But the Court of Appeal in New Zealand was very strong in saying that as a matter of principle and policy, tort law was not an appropriate vehicle for addressing the problem of climate change. And in Australia, similarly, there was a group of students who brought a case against the Minister for Environment, claiming that the minister had a duty of care to Australian children to protect them from physical harms of climate change, which would arise if the minister approved an extension to a coal mine. And at first instance, the students were actually successful. However, the full federal court rejected the new novel case duty of care. And they did say that it's only the High Court, which is the final appellate court in Australia, which could develop the common law and engineer new duties of care in this way. So perhaps it could be civil law, common law. There are some differences arising, but it's interesting to see what's happening in those spaces. In the interest of time, we might just pause on the international criminal law and come back to it if we have the time at the end. But to move on to the more increasing risk cases, starting with financial disclosure. So in cases brought about financial disclosure, these are increasing, definitely on the rise. There are more and more cases being brought by shareholders against banks, pension funds, investment funds, and sometimes also directly against their officers. These actions tend to feature a claim by the shareholders that the particular institution has failed to include climate-related risk into their decision-making and/or in their risk policies. So then they say that there's been a failure of the institution to disclose climate risk to their beneficiaries. Beverly, can you tell us a bit about, there was a securities fraud class action brought against ExxonMobil in Texas in relation to misstatements made by the company about carbon costs?
Absolutely. I think that as we move into these more commercial-based matters, this is really something that I think has the potential to impact on clients and corporates, irrespective of what country they're based in. I think that there are principles that we can learn from these that could directly impact South African-based clients. So in this particular matter of Exxon, interestingly, Exxon and its 4 directors have been cited in their personal capacities. The allegation made against them is that they have materially and intentionally released misleading statements into the market regarding the value and the amount of Exxon's oil and gas reserves, and that by releasing these false statements, it intentionally pushed up, or at least retained, a high share price. And what has been alleged here, and what has come out through the applicant's investigations, is that the directors of Exxon, when delivering statements into the market regarding its market share and the value of its untapped resources or resource reserves, it used a different calculation than when it calculated what its own internal operating and working requirements and costs were. And in this regard, Exxon made use of a proxy carbon cost. Now, a proxy carbon cost, for anyone who isn't yet aware, is where companies factor in, it's not an actual carbon cost, but they factor in a potential carbon cost when doing forecasts for future investments. It assists greatly in assessing the actual life cycle costs that might apply to an investment by taking current costs or the upfront costs together with those operating costs, which would include a potential carbon tax going forward. And if you use a skewed or a reduced likely carbon tax in these forecast calculations, I'm really simplifying it right down, then it can create the impression that your company's future projects and investments are potentially more valuable than what they will be in future. So the allegations here are that directors fail to notify the public adequately of the impact of climate change on its ongoing business and the cost of that ongoing business, which it alleges impacted the share price. What happened in this matter is that parties were purchasing shares on the open market, and then all of a sudden, Exxon had to basically abandon 20% of its resources, untapped resources, given the cost and impact that it would have on climate change. And this impacted the share price by each share price being dropped by $2. And that's why shareholders and members of the public brought this application saying, you knowingly knew about this and you didn't disclose it, and it impacted our thinking process when we purchased your shares, and now our share is lower. So this is a good example. It's an ongoing matter, but it's an example where Exxon and its directors failed to take adequate precautions in the publication of its likely future profitability and value of its resources, and it has resulted in a class action being brought against it.
Wow, that's another really interesting case, and something that I can foresee having parallels in other jurisdictions in the future. And just to quickly note, in terms of financial disclosure cases, potentially, just as we spoke about before, in Mauritius, with the Bank of Mauritius guidelines soon coming into effect and the disclosure requirements and annual reports, there could be a potential to see maybe some regulatory cases in this space, with the upcoming obligations as of 1 Jan 2024. So our Mauritian financial institutions should just take note and start thinking about that obligation. So let's move on quickly now to directors' duties. This is a big one. So directors are increasingly being held to more stringent standards in assessing and managing climate risk, which is well recognized in Commonwealth countries like the UK, USA, Canada, Australia, South Africa, but also increasingly in Asian countries as well, like Singapore, Japan, Malaysia, India, and even the Philippines. So our first category of directors' duties is the duty of to exercise reasonable care and diligence. This concerns a claim that will allege something along the lines of there's been a failure of the directors to make considered decisions because they failed to properly consider and manage foreseeable climate risk.
Yeah.
There's a world first case which was brought just in February this year against Shell by one of its shareholders, the activist group Client Earth. Beverly, can you tell us a bit about this case?
Absolutely. Gillian, if there is a case to watch at the moment, it's this case. It was brought on the 9th of February this year, based on the Companies Act of 2006 operating in the UK. Now, when we go through this case, if we can just listen to the nature of the wording, and you may get a sense that you've heard this wording before, and that's because our Companies Act has very similar wording to this Companies Act on the provisions that are being applied to the directors. And I think this is a case to follow, because I think that this is going to set a trend, and it will be a precedent on which other companies can hold their boards of directors to personal accountability, I think, across the world where they have these types of duties. So in this particular case, you're quite right. Client Earth, being a shareholder of Shell, brought an action together with, listen to this, 12 million shareholders. 12 million shareholders who in total constitute $500 billion of value. That's the number of shareholders that are holding the board of directors to account in this matter. And that is a significant move. What the shareholders are saying is that Shell's 11 directors, the board directors, the 11, have failed to take adequate steps to adopt and implement an energy transition strategy that would safely guide Shell and protect its value in shifting to a net zero strategy by 2050. In failing to take these steps, it is alleged that the directors have breached their legal duties under the Companies Act. And which duties are those? And this is where you'll see the resemblance with South African Company Act wording. It says that they have the duty to promote the success of the company and to act with reasonable care, skill, and diligence in discharging those duties. Now, that's the same as South African directors who are required to act with reasonable skill, care, and diligence. And one of the factors that was identified was that Shell's board members had continued to approve what they consider an overinvestment in fossil fuel projects that would extend into the 2050 period. And its shareholders found that this was just untenable. With a move to being net zero, they found it irresponsible and negligent of Shell's board to invest shareholder funds into fields and projects that they did not believe would generate sufficient income and would in fact impact the value of Shell. So this is really a case that we need to keep our eyes on. And we'll make sure that we report to clients in the form of an article as this matter progresses.
Be looking forward to that update. Just to note that in Mauritius, the director's duty is a lot more, it's more general, it's not quite as targeted. There aren't specific environmental considerations that are in the Companies Act 2001. So for the time being, we don't see a claim in Mauritius being able to be brought under that duty for now, but if there was legislative change and reform, that's something that could be opened up in the future. And now moving to the second director's duty, to act in the best interest of the company. So this director's duty hasn't been the focus of as many climate cases as the duty to act with care, diligence, and skill. But there has, just quickly to mention, there's been increasing judicial commentary about the potential of this director's duty to form a basis of a claim in future. So because Commonwealth countries like the UK, Australia, New Zealand, they recognise that the duty to act in the best interest of the company requires directors to consider the interests of shareholders as a whole. And in places like Canada, there's now even a push for directors to take stakeholder interests into account. And so if you need to consider those broad interests, then your duty is obviously going to be a lot larger. And the judicial commentary coming out of Hong Kong, the legal analysis has said that a director, when acting in the best interest of the company, is legally entitled and obliged to take into account risks and considerations arising from the effects of climate change. And in Australia, there's also been judicial commentary saying that the director acting in the best interest of the company must take account of, and the board must report publicly on, climate-related risks and issues. So we see this as an evolving basis for potential liability, and something that directors will need to be keeping in mind. Okay, and now we're running out of time, so quickly just mention greenwashing, which is a very broad term. It can include many different kinds of conduct in many different sectors. Beverly, can you just give us a quick overview of what greenwashing means?
Okay, just very briefly. So simply put, greenwashing is when you make out that your particular product is either environmentally friendly or has a positive impact on the environment, when in fact it does not. And I think this is going to become an area with increased focus as the market is demanding more environmentally friendly products and processes.
Great, thank you. And let's just very briefly, can you tell us a little bit about the class action that was brought against Coca-Cola about the recyclability of their plastic bottles?
Sure. So Coca-Cola faced a class action in which the applicants alleged that the use of single-use plastics for purposes of its drinking water bottles, which had clearly demarcated that the bottle, the cap, the label, everything was 100% recyclable. And the allegation against it, that this was simply reckless and incorrect statements, and an order was sought directing Coca-Cola to remove that labeling from its water bottles. The allegation was that the United States of America does not, in fact, have the capacity to fully recycle every single piece of recyclable plastic. In fact, it appears that it's only capable of recycling under 30% of the plastics. So the allegation is that you can't simply say that your bottle is 100% recyclable when, in fact, you know that the production processes don't actually allow or have capacity to recycle all of those bottles. The court, however, found that this was just a little bit too broad, that recyclable means the bottle is recyclable. Coke isn't undertaking that it will be recycled. It's simply saying that it is capable of being recycled. So in this instance, the court did not come to the rescue of the applicants, but at least it gives you a suggestion of how broad these categories can be, right down to whether something is or isn't recyclable in a factual sense, as opposed to simply the potential of being recycled.
Interesting, thank you. It'll be fascinating to see whether that obligation gets pushed and the standards, maybe they're held to account in a high level in the future. So just to round off, there are two other categories of claims in a high risk type of cases. So there are public law challenges to environmental and planning approvals. So there have been a lot of claims brought against an approval in the public law sphere, against a mining or a major construction project on the basis of increased climate impact on the earth. And then also in ISDS, there have been a growing number of investor-state arbitration claims brought by fossil fuel investors against nation states, where those states have started to bring in legislation to implement climate change action measures. So there's the Energy Charter Treaty, which allows investors to claim compensation for unfair losses that have been suffered because of government regulation. So there have been various entities which are suing places like Italy, the Netherlands, where they're starting to ban different carbon intensive mining and those kinds of projects. So thank you so much, Beverly. Now I need to move on to the other side of the coin and have a chat with Thierry. Let's talk about defending climate change suits. And so not all of the climate change claims involve natural disasters, but many do. And so one example is last year in an Australian town of Lismore. They had two incredibly destructive flood events in the space of about 3 months. They had record high water flows, but also what's relevant to know is that Lismore is a town with a long history of flood events, of having about 138 floods in the last 152 years. So if we say that a resident of Lismore sues its local government for damage suffered from flooding, and says that the government's failed to take adequate preventative action from this foreseeable risk of flooding in their town. Thierry, if we think about the concepts of faute and force majeure, how could these kinds of doctrines potentially apply in a civil law context in these kind of natural disaster scenarios?
Thanks, Judy. Well, we had a similar situation in Mauritius, where we had a flash flood, which was dramatic. It flooded half of Port Louis, 13 people died. Numerous businesses and shops were affected. And we lodged a claim in tort in Mauritius against government and against meteor services. And this claim was based on a previous case we had made concerning a cyclone. And that case went right up to the Privy Council, and where the Privy Council set the standards of force majeure and foreseeability. Now, there were two judgments in this case, where if you prove negligence, and there has been negligence, you cannot have a defense of force majeure. And for force majeure to be able to have a defense of force majeure, you must be able to prove that it was not foreseeable. Now, going back to the flooding, what had happened in Mauritius was that there were a number of negligences that had occurred. And the flooding, even if it was an extraordinary flooding, had not reached the level of being unforeseeable. So the case is still ongoing, and we'll see how it unfolds. But let's say that the criteria of climate change litigation in Mauritius on foot will be about the level of foreseeability. If something is foreseeable and you know it's coming or can come, not to have taken precautionary measures or taking a policy to have precautionary measures can make you become negligent and can cause you to be sued.
And do you think that the standard of foreseeability will become lowered and it's going to be an increasing burden?
Foreseeability is becoming more and more because with the technical science, climate are more and more foreseeable. The standard which is required by the courts is lowering. The burden of proof is being lowered, and the level of to be able to get the defense is being raised. So more and more, there is a likelihood of being able to sue in situations where previously you couldn't.
And if we have a think about company directors, are there any protections from tort claims that they might be able to make use of under civil law?
Well, normally a director cannot be sued for civil law under Article 1382. The common law, company law legislation in Mauritius is that if you want to sue directors, you have to go through the company first. So you have to go through a derivative action. And then you have to show that the director has been negligent. I mean, it will always come back to negligence. And or whether the company the directors has not taken steps that the company has imposed as policy. So if they have not followed the policy imposed by the company, or if there are regulations, and there are being more and more regulations, the directors have not followed regulations, then they can take derivative actions, but the level is rather high. I must say that for the shareholder to be able to jump to the director.
That's good to know. Let's move on to talk about the wider impacts of increasing climate litigation. So Thierry, what are you seeing as some of the implications on business more generally from this increasing risk of climate litigation?
Well, in taking into account what is now the criteria of investment, where you are going to put your holding company, the litigation risk is very, very high on the agenda. When you are doing cross-border and you are putting your strategy to going to hold your investment, let's say across Africa, you start looking at where is the litigation risk. And when you're looking at where is the litigation risk, obviously climate litigation, class actions, huge environmental risks are elements that you take into account, and you choose a jurisdiction which is less prone to be sued for directors rather than those who are more lenient. So it's a factor nowadays. It's very nice for shareholders to sue directors, but the other side of the coin is that the directors move their office to jurisdictions where it is far more difficult for them to get liable.
Are there any jurisdictions that, for the time being, have a sort of lower litigation risk than others?
Mauritius, obviously. But you know, we have to be careful there. All these cases, and most of them, are directed at public listed companies. And now you don't move a public listed company very easily. Class actions and so on are more and more what we are seeing directed against those public listed companies. But the private companies, the specific mining companies, which will be hotels and which are affected greatly by climate change, they are looking at how to structure their investment and taking that into account. Yes.
And just to add a little sprig for Mauritius, that we don't yet have class actions, so that could be a potential.
We don't yet have class actions, but some try to circumvent that by having associations and so on. But it's not yet part of the ball game to have class actions in Mauritius.
And for some of the industries like insurance, mining, energy, transport, these ones will be facing bigger changes than other sectors. What kind of impacts do you think that these industries might be facing?
Well, insurance industry is obviously in the front line. They are the one taking the liability. They are the one who, when they pay, they turn around and sue and see who has been negligent and where they can grab the one who has been responsible. And then they are the ones giving the D&O insurance covers. So insurance is very, very much concerned about what is happening on the climate change, on these new litigations, because these are massive claims that can come and for which they need to be prepared.
Great. And now let's just turn, we haven't got much time left. Let's talk quickly about mitigating climate change risk. What kind of practical things or strategies can our clients be doing or working towards to help them mitigate climate litigation risk?
Well, extremely quickly, I think we are running out of time. Just to enumerate them, I think clients need to be proactive. They need to look at where there can be liability on climate change. They need to address these management issues. They need to have policy measures taken. They need to see what are the industry standards. They have to see what needs to be done internally and what can be outsourced. They need to hire consultants to look at how to address those different issues. They have to understand the regulatory regime. They have to look at what's the new trend. They cannot just sit there and do as if these doesn't exist. They have to make disclosures. The public listed companies have to look at that into their reporting line. And obviously, there is quite a new, how would I say, trend is that now is regarding their insurance policies, the disclosure in their insurance policies, because if they don't disclose those risks, when the claims will come, the insurance will turn around and say you failed to disclose. And so these are new, and directors and companies might not be aware and on the ball of what's going on around the world. But this is an area where what happens cross-border hits back on the local turf. So one needs to look what is happening around the globe and to be prepared that these type of litigations and risk are imported into the local market.
And it sounds like there are a lot of proactive things that our clients need to be starting to do, and obviously that
Indeed.
has a cost that comes with it. But would you say it's a case of a stitch in time saves nine, that it's really wise to start planning and spending a bit of money if need be and consultants and things now, so that you can be ready and not sort of stuck later when everything's already in place and there's legislation that you're non-compliant with?
Obviously, I think that to take steps beforehand is better than to react when it hits. So it is worthwhile taking the time to address these issues, definitely, particularly the public listed companies.
Thank you so much, Thierry. I'll now pass back to Jess to conclude today's session. Thank you everyone for joining us. We hope you found that webinar interesting and useful, and we will be circulating the slides to you all at the end. Thank you. Goodbye.